Good morning, everyone. Thanks for joining us for another stakeholder meeting on some draft rules. I am Shana Horton, your host as always. With me today is not Garth, but Thomas Graham, Matthew Cherry, and John Sudbury. They're going to be helping me answer your questions about Chapter 45, Chapter 49, and the e-commerce advisory. Today's date is October 15th. It is 10:04 a.m. And let's go ahead and get started with Chapter 45 draft rules. As if you guys have been following along the last couple of years, we have gone through every other rule in Chapter 45, and these are the ones that remain that we have not yet modified. So they're being modified in various ways and for different reasons. Some of them are going to be more interest than others. But first of all, we're going to take loyalty programs out of order. That's a brand new rule proposed 45-102. And we're going to take that out of order since it's just brand new. And then we'll go back to 45-101. And I'm going to go ahead and just pass it to Thomas to explain what the loyalty programs rule is all about.
Good morning. Thank you all for being here this morning. I see we got a bunch of participants and we really appreciate that. 45-102 lays out loyalty programs, as Shana mentioned. We have been approving and reviewing loyalty programs for a long time. Our big intent with loyalty programs is to really separate them out from coupons. And it's been common practice in the industry for a long time. We wanted to stick this out in rule because we've had a lot of requests for what the agency standards are when reviewing these. And we've expanded over time on what we allow, going back to really the first loyalty program I think the agency approved or looked at was 20 plus years ago, and it was the Randall's program, Randall's card. So we've expanded a lot from then to where we are today. We think that loyalty programs are legal. We want them to have their own rules so that they're different and separate from coupons. We look at the intent of the loyalty program is really to drive consumer loyalty, right? And consumers returning to the same retailer's website, to the same retailer. And we think it's okay for discounts to exist. If you're a loyalty member, you can earn points. This rule covers earning points. It covers having free drinks and free alcohol based on the number of points you earn, or maybe once a month as a member, you get a discount. Okay, so we lay out the elements of that in this rule. We do want to make it clear that this does not allow for coupons. And we also want to make it clear that you're being required to show that you are a member, whether that be your ID or maybe a phone app, something along those lines, does not qualify as redeeming a coupon to receive a discount. So if you're a member of a loyalty program, you're asked to show your loyalty number, whatever it may be, to get a certain discount. We don't consider that to be a coupon. We just consider that a form of identification. And one of the things I want to point out on this rule is that when it comes to on-premise retailers, that's really about the only place that we have some restrictions in place. And we do limit the number of free alcoholic beverages a consumer can receive based on a loyalty program or as part of a loyalty program at an on-premise location. We limit that back to 45-103. And 45-103 is our on-premise promotion rules, and it speaks to consumers not being able to receive more than one free alcoholic beverage per day at an on-premise location. So this rule references that. I think that's really the main thing folks are aware of. If you are going to offer discounts or free beverages to your consumers at on-premise as part of the loyalty program, you're going to be limited to one free drink per day. Now, it's on top of that we think it is a little bit different than for you to be able to say that at that on-premise, we want to offer a 10% discount to our members or a 20% discount. That's fine on the end of the check, whether it be on the drinks or the check as a whole. But again, just we are limiting that one free drink using 45-103 to do so. So wanted to cover that and we laid that one out before coupons because we've actually tried to lay out this rule in the past. This is a similar rule to what we laid out years back, but I think it's even more open-ended and allows for a lot more activity. So if there's any questions on that one, we'd be happy to take them.
We actually can't see today if you're raising your hand. So if you are raising your hand, just unmute yourself and introduce yourself and go ahead and ask your question or make your comment.
I have a question. This is Tyler Rudd with the Wine Institute. For the loyalty programs, does the discount apply to the total bill, or are retailers or can retailers apply it to specific alcoholic beverages?
Tyler, you can apply it either way. So it could be specific to an alcoholic beverage, or it could be to the total bill. It would be an issue if this was a retailer and an upper tier member was driving that discount for a specific brand, right? If there was some kind of incentive to the retailer to push that brand. But if it's the retailer on his own pushing a specific brand and offering a discount on it, that's fine.
Okay, thank you.
Yes, sir.
Okay, other questions and comments?
This is Amy, and I apologize. I got in here late and couldn't get my volume going. So if you've answered the question, my apologies. Can the commission just talk a little bit about some of the violations that they're seeing that have prompted the review of these and what the goal is specifically?
Amy, we haven't seen a whole lot of violations, I think, recently, because as we've reviewed these programs, we've become more flexible in what we allow. Historically, when loyalty programs first started coming to work to us, there was a lot of debate over what constitutes a coupon and where the problems would be there, and what makes a loyalty program different than a coupon. And we had multiple retailers come in over the years and ask us to review their loyalty program. And so that's really what prompted this. We've had those questions in place for a while. Our field staff has had questions about what's legal with the loyalty program and what's not. So the intent here is really just to lay out loyalty programs are legal and we don't consider them coupons, and you can offer discounts on beverages or even a free alcoholic beverage to consumers. And we're not going to consider that a coupon under these circumstances.
Oh, this is George from Starbeam Liquor. Quick question. You mentioned everything about the on-premise consumption. How about off-premise?
So the rule speaks to both, and you're not limited in off-premise to offering discounts or even giving free beverages to your consumers. So if they're a member of your loyalty program, you can pretty much give them what you want to as part of this program, and we're okay with it. I recommend putting rules together for your loyalty program so the consumer can see it, obviously, but we do limit the drink to one free drink per day for on-premise consumption. But again, that's because we have rules in place for on-premise promotions, and they are public safety rules to ensure that we don't have intoxicated persons, or at least we're not encouraging them. So as far as to-go alcohol beverages and offering a discount on that, this rule doesn't limit it. It allows for it.
Justin Engel, Houston Cider Co. asks, what's the stance of other state alcoholic beverage commissions on loyalty programs? How will this law affect national chains that operate in Texas? And will this change adversely affect their business in Texas?
Justin, I don't think so. I couldn't tell you exactly what the other state laws are on loyalty programs. But what I can tell you is this particular rule for loyalty programs is really pretty much allows everything within these guidelines, and limits coupons and then one free drink per day, like I said, for on-premise. So over the years, as long as, over the years we've had these things, we've had certain restrictions in place, and this has really opened the door for loyalty programs across the board based on the programs we've seen in the state. So I think the two things to keep in mind here, as I mentioned several times, the on-premise one free drink per day limitation. And then I would keep in mind as well that if you're a retailer out there, you shouldn't be offering some kind of discount on one particular beverage because an upper tier member provided an incentive to do so. So of course, we still look at tier violations, and we always will. And if you are pushing a particular beverage because an upper tier member is underwriting that discount, of course, that's going to be a violation. But outside of that, this rule allows for different kinds of programs and loyalty.
Anyone else? Okay, follow up. If a permit holder is able to do both on and off-site consumption, would the loyalty program be able to give the consumer a free on-site beverage and potentially unlimited off-site beverages?
Yes.
It's not often you get an answer that clear from an agency. Yes. Anyone else on loyalty programs? Okay, not seeing any additional comments or questions, not seeing any hands raised. The last question was, if a permit holder is able to do both on and off-site consumption, would the loyalty program be able to give the consumer a free on-site beverage and potentially unlimited off-site beverages? And the answer to that is yes. So, you give them one drink on-site and then they would be able to purchase to go.
And you could give them, if
Right.
you wanted to give them a bunch of free alcohol and give away your inventory to them, as a loyalty member, you could.
Okay. All right. I think that's gonna do it for 45-102. Then it looks like, unless anyone else wants to comment, we will go ahead and now go back one, starting off with 45-101. I'm gonna scroll to that. And some of these rule changes you'll see, I mean, for the most part, they are conforming and not terribly substantive. Okay. So 45-101, rebates and coupons. The elements of this rule remain the same. Our goal was just to update the language, but not change the elements or prohibitions in the rule. So it still prohibits coupons, just as we always have. So in C, we've added a little bit of language to sort of clarify the difference between the first and second sentences of the subsection. Can you move the chat off?
I think we got one more question about city ordinances.
Okay. All right, before we move on to 45-101, we have one more question. Are there any city ordinances that go against the loyalty programs? And I'm not aware of any.
I'm not either. I'm not familiar with the city ordinances, but generally they don't. I would think so.
So back to 45-101, we've added to subsection C that the first sentence and the second sentence kind of look like they could have been interpreted to conflict. So we've added that the free cents off rebate or free non-alcoholic beverage or item or product is allowable, but if it's for a product that the licensor holder does not sell. And then the second sentence, they can offer a discount rebate cents off for any non-alcoholic product that they do sell if it doesn't require the purchase of an alcoholic beverage. So it doesn't change the rule. It just makes it a little bit clearer what the difference is between the first part and the second part. So, for example, if you have an offer to mail in $3 in this form and we'll send you a Duff beer cap or whatever, that's fine as long as it's redeemable directly through Duff beer and not a retailer like a grocery store. Whereas an offer to mail in $3 in this form and we'll give you a discount on, Fogo charcoal is not okay because it's not something that they produce. Any offer for an alcoholic beverage, not okay.
Right.
So that's the long and short of it. And again, C is it really just a clarification, and everything else is just updating the language. We got rid of stamps because no one uses stamps anymore. So it's just the green and gold stamps and all that kind of thing. It's just out of date and anachronistic. So we don't need it anymore. That's really all there is to the changes in 45-101. Does anyone have any comments or questions about 45-101? I see Marcus's hand up.
Yes, Marcus Schwartz, Bracken Schwartz, LLC. With the elimination of manufacturing, wholesaling, and retail level permittees, and now it's just a permit holder, does that interplay with D then prevent coupons? I'm thinking of a certain headquartered airline that is famous for their drink coupons.
As you're saying, so since they don't have a permit anymore, is that what you're saying, Marcus?
Well, they were, airline permittee, which is kind of quasi not in the 3 tiers, right? And you've
Right.
eliminated the 3 tiers, and it's now any permit holder,
Okay.
no coupons.
Thanks for pointing that out. We will look at how to fix that language, especially now that they're not a permit holder at all, but regardless of what tier they're in. So, but I think D covers allowing for that. We just need to make sure that it includes those folks who don't have necessarily a permit anymore.
Mhm.
Appreciate it. That's all for me.
Good catch. Looks like Dewey Bracken.
I was just echoing what Marcus said on the D, because prohibits any retailer from offering. And again, you might have some non-permittee offerings same, so.
We'll take a look at that.
Thanks, gentlemen. It looks like Kyle had the same topic there.
Okay, anyone else? Go ahead and unmute yourself.
We really looked at this rule because we've looked at changing in the past, and after agency reviewed it in the past, it was pretty clear that we needed to ensure we didn't make any changes here and that the rule aligns with statute. So if you see anything that looks like miswording, let us know, but we really did everything we could not to change the intent of the rule of the current language, just really update it. Go ahead, Shane.
We have a question. What's the difference between an on-premise retailer granting a discount at the register for a certain alcoholic product and a retailer backed coupon on that certain alcoholic beverage product that is redeemed at the register?
And this is something that was kind of debated years ago. Statute just flat out prohibits coupons for alcoholic beverages and discounts and purchases in chapter 102. So I think offering a discount at the register, a lot of folks do that, but offering a coupon that has to be redeemed by the consumer and drives the consumer in to actually redeem that coupon. It goes back to different things, but essentially the alcoholic beverage code prohibits coupons altogether.
All right, we got to keep moving. We've got a lot to cover today, so let's go ahead and get down to 45105 advertising, which is the next section that we have improved upon. Again, so the main thing that we've done here is clarify that drive-through menus can include alcoholic beverage to-go prices at a size that they can be read from the drive-through lane. So since we have that to-go mixed drinks and that sort of thing these days, that's a necessary change to those signage limitations. And then let's see.
And we're going to make a change to that to include mixed beverages now that they can sell together.
Right, right.
So.
Exactly. So that, I mean, that's the purpose of the changes to 45105. And yes, we know that right now it says it doesn't include mixed beverage, but that's because we've drafted this before the most recent legislative session. So we will update that to include mixed beverage. Anyone on 45105? Go ahead, Marcus.
Yes, in addition to 3B, is there any reason that BEs are left out?
No, we can include them as well, Marcus.
Thank you.
Thank you.
Got it. Okay. Let's keep on moving. 45107. Oh, private clubs too.
Well, private clubs are going to be prohibited from selling to go though.
So it won't affect them.
Yeah. but I don't think it's going to be a change for private clubs unless statutorily were they granted the authority? Okay,
Yep, and
So it
added
was-
into the consumer delivery permit as well.
okay. So private clubs do need to be added. Thank you, Matthew, for that.
I have one question, if it's all right. It's Edgar.
Please.
I noticed that under the advertising rule, it includes food and beverage certificate holders for mixed beverage permittees, but there's no food and beverage certificate requirement for on-premise wine and malt beverage retailers. Is there a reason for that discrepancy?
On-premise wine and beverage retailers and malt beverage retailers have always been able to sell to go, regardless of whether or not they have a food and beverage certificate. So to-go sales were something they were always allowed to do, and they weren't required to have a food and beverage to do so.
Okay, and the other thing is under the advertising rules, it doesn't say anything about mixed beverage holders having to have food and beverage certificate. I'm just kind of pointing out that there appears to be some sort of discrepancy or disparity. That's all.
Thank you, Edgar.
Okay, has the use of QR codes and digital menus been at all discussed with regards to the changes in Rule 45-105A? We did talk about that a little bit, but
It was something we talked about, but it wasn't something that we decided to tackle at this time.
you have any thoughts on that, please feel free to send them to rules@tabc.texas.gov. That might be something that we need to look at in the future. We know things are changing.
Absolutely. Thank you, Trey.
45-107 are just changes to conform to House Bill 1545, the Sunset Bill for beer ale consolidation. So there's nothing really to discuss there. 45-109, restocking and rotation of alcoholic beverages. This one is, we've updated it to reflect current practices that are currently under advisories 36 and 63. And that is essentially for the sake of transparency. Some of those things make sense to have in rule. So the changes in subsection C here come from advisory 36. It's been in practice a long time. You're no longer limited to 30 days for product display enhancements as long as whatever that enhancement is returned after the promotional period. And then subsections F, G, and H are a reflection of advisory 63. So the 40 hours per week standard, that's our way of ensuring chapter 102's prohibition on impermissible services or things of value. This is what was agreed upon in the stakeholder process developing that advisory. It seems to be working relatively well. And of course, if an event is going to require more than 40 hours in the week, something like a 4th of July weekend, this allows a distributor to do that just as the advisory does now. So it's really what was agreed upon in the advisory. We're just trying to put it into rule so that it's open and transparent. Questions and comments on that one, and we have to really hustle because we've got a lot to get through. All right, I'm not seeing any hands raised. Great. Okay, let's go ahead and move on to 110 then. 110 inducements. Anytime there's a dollar amount, dollar limitation in a rule hasn't been changed in a while, we want to think about whether that ought to be raised. So, and also industry, of course, has been asking us to raise this value in C4A for inducements for a long time. So hasn't been increased since it was adopted in 1998, and increasing it just for inflation would be around $840. So here we're just throwing it out there at $1,000 to get everyone's feedback on that. And let's see, we also took out the limitation to ground transportation. We know there's an interplay here with new alcoholic beverage code 10207A1. This was drafted prior to that. So under 10207A1, travel to a manufacturer's facility in Texas by any means is not considered an inducement. So that will have to be carved out here and to ensure compliance with that new statutory change. Travel outside of the state, which isn't covered by the new statute, any means of transportation would be allowed, including air, up to $1,000 under the rule. That is the purpose of those changes. Questions and comments on the changes to 45.110. Okay. Question, what is the normal record retention period? Should reflect the standard and not 2 years. Standard audit may miss an incident because of the 2-year retention period.
2 years is the standard.
Yeah, 2 years is our standard, and in fact, in every rule that there is no statutory requirement. Otherwise, we have been changing from whatever it says to make sure that we are consistently at 2 years. So, and that's based on what audit has told us is sufficient for their purposes.
I will add though that there is with certain stuff, with certain audit records, especially when it's involving taxes, I think it's in chapter 201 of the code. You will find a reference that does talk about 4 years.
4
So
years.
people should kind of just be mindful of that as well.
Right.
For tax purposes.
Right. That, and that's the exception I was talking about, unless if there's a statutory requirement that's otherwise, for our purposes, we're doing 2 years, but yes, with taxes for. Okay. All right, let's keep moving.
This is Bill DeFore. I have a question, please. Can you hear me? Hello?
Here you, Bill.
We can hear you.
Okay, I'm sorry. On that one about the $1,000 per day per occurrence, that does include transportation?
So yes, it includes transportation, but unless the transportation is to the manufacturer's facility within the state of Texas, in which case.
It does not. Okay,
It's
so
been as much-
that's out of state then.
Yes, out of state is subject to that.
So, Bill, we did this rule prior to the last legislative session as well. So we need to update some of this to reflect that, but we've reached out to TPSA and some others on that as well. So if you got any language you want to suggest, let us know. But
Okay.
we do forms.
Appreciate it.
Okay. 45.111, we struck the 200-foot requirement. Here we go. On signs at charitable or civic events to align with Sunset Bill's changes. And then we removed directly as far as advertising alcoholic beverages be received directly by the charity or civic endeavor. We know that sometimes they're received by an event and whoever's putting on the event, and then they give it to the charity or civic endeavor, and that's fine with us. That's our current practice. So we're just updating it for that. For clarity on 45.111, is it still allowing signs and just removing the 200 feet limitation?
Which was the sunset.
Right, yes,
When they got rid of all the outdoor advertising regulation stuff,
right,
we were able to eliminate that.
right. So signs are allowed and we're not concerned about how close they are. I'm just gonna keep on moving. We've got 2 more here, 45.112. These are primarily non-substantive changes, just to standardize terminology like administrator to ED. Update for beer ale consolidation and improve upon the writing a little bit. And Thomas is going to explain subsections F and G a little bit more. There about menu cards folders.
So we wanted to update this language. Historically, there's been language in there about beer and menu cards, and blank menu cards could be provided by beer distributors to retailers. Retailers could then go stick them in their typewriter and type on them the rest of their menus. Things have changed a lot. Practices have changed a lot since then. It's fairly common these days for wholesalers to print wine lists for retailers. And we're updating the language here to allow for that practice. One, for beer as a promotional item, if it's being paid for the way a promotional item has to operate under 45.113, of course, which this rule references. And then for wine and spirits, in accordance with 45.117, we will allow wholesalers to print wine lists and spirits drinks lists that change pretty often for retailers. provided they're under $101 per brand per year in accordance with 45-117. So 45-117 talks about advertising specialties. What we're saying is we think it's okay for upper tier members to print these drink lists in accordance with that advertising specialties limitation. And I think this is, like I said, it's been a practice in the industry for some time. We're just making sure that we put it in rules so that we aren't writing tickets when we come across this out there.
Questions, comments on 45-112? Going once, going twice. Okay, 45-120 co-packaging. The changes in B1A are just for sunset updates. And then down here in subsection D, and we've gotten some feedback from package stores concerned about, the line on price regulation. So we're just removing that confusing price differential standard for co-packs, and we're just replacing that with a simple reference to the applicable statutory standards. So, and that's in alignment with the advisory that we just recently put out. So any questions on that before we move on to our next item? We're about 5 minutes over on this one, so. All right, we're gonna wrap on these chapter 45 changes. I know you'll probably see some things later that you have questions about, and you can always reach out to me or to Thomas about your questions and comments on chapter 45. Okay. Item number 2 on our agenda is chapter 49. This is a proposed new chapter to house essentially the safe harbor regulations. So we'd be moving some from where they are right now, and then we have revisions to the retailer safe harbor. Let me just let you go ahead. Do you want to go ahead and talk about it a little bit, John? Or
we can go for short on time. We got questions.
We're good. We got 20 minutes.
Okay. 49 obviously now lists a definition section that we didn't have before. Employee was in the rules, but now it also it covers employer, delivery driver, and the differences between those and incidental employees. Down. There we go.
This one's same.
Yes.
Oh, not employee. Yes, no, this one's different.
Well,
Let's come back to 49.3. 49.4, there's no substantive change. This is just moving the consumer delivery rule that we all went through and worked on last year. It was approved by the commission last year, moving it into this chapter. And of course, differentiating it from the other, differentiating it from the rule immediately preceding it when each applies. And then 49.5, I don't think there were any significant changes to this either. So this is just moving that rule. Here, there might be some changes in 1 and 2. So let's go back up to 49.3 because that's where the changes are. Do you want to go over that? I mean, essentially, what we've done here is to try to eliminate some of the investigative problems that our agents have related to compelling documents that would prove that, or trying to prove a negative with respect to safe harbor provisions. And so just if you want to just describe what the problem has been.
Well, in the past, first of all, safe harbor is voluntary. It's not required in any way by the commission. So the permittee is the one that would be in the best position and is in the position to hold that evidence and have that access to those records. So it's an affirmative defense that they can use at SOA or in a district court dram shop case. And since they possess that evidence, they're the ones that should have the burden of presenting it, instead of TABC simply trying to scramble to prove the negative. Because we're always beholden to the permittee in order to get the evidence we need to assess what happened and what the situation was.
So what this rule would do would be to require the permittee to provide those records to prove their eligibility, rather than for the commission having to prove the negative without the access to the records in many cases. And I know that is a change. But, this is an extraordinary affirmative defense. Statute doesn't require any affirmative defense at all. And it's in line with district court, procedure. The plaintiff doesn't have to prove your defense for you. So that's, there's no burden shifting like that in a district court for any affirmative defense. So it just, it's really unusual the way it has been. And it's really not very, it's almost untenable, because it makes it almost impossible for the commission to do its job and to protect public safety. So what we're trying to do here is just make it an actual affirmative defense rather than a passive one, and make sure that our license and permit holders are giving us the information we need to prove their eligibility if they do choose to invoke safe harbor.
Absolutely.
So questions and comments on that?
This is Edgar Korzanowski from Griffith and Hughes. Yeah, I have a concern about this, and I've written about it, and I'm just drawing it to the rest of the group's attention here. But the state Supreme Court is pretty clear that a plaintiff must prove that there is direct and indirect encouragement. And here the commission appears to be defying Supreme Court precedent, trying to understand what the authority of that is.
Edgar, can you elaborate on what you mean by that? What section?
Well, I'm referring to several sections. I mean, one of those is that you're requiring that the retailer essentially prove on the front end. You just said that they have eligibility for safe harbor. I mean, some of them is that the employees have not had any lapses in seller server training within 24 months of the incident. Also, they must prove on the front end that they've had some policies. I mean, that's something that, well, quite frankly, TABC needs to prove. And why is it that you're shifting that back to the retailer?
This is a defense, so it's something that the retailer is invoking. We're not prosecuting it. It's a defense, and so I mean that's what an affirmative defense is. That's why it's affirmative. The person has to do something to invoke it properly. I think that's in line with how affirmative defenses are treated, contexts. So.
And I understand where it comes from. It's just I think the Parker case is very clear what needs to be required, and there's just two things, and that is that to be entitled to that defense, and that's number one, that they require employees to attend commission-approved training, that the employees actually attended such training. There's no other requirements. So I'm just leaving it at that. I understand the commission may disagree respectfully, but I wanted to point that out. Thank you.
Thank you.
Janie.
Hi, this is Dewey. I would echo a little of what Edgar's saying there, because the way I read that Supreme Court case as well, there isn't an affirmative defense for the employer to show that the employee in question had actually attended the course, and to show that they're not, and that they require their employees to attend the course. After that, what the case says is it becomes the plaintiff, which in this case would be the petitioner, the TABC, to prove the element of direct or indirect encouragement. So I've had a problem with this rule since its original inception, because I think arguably the whole thing is subject to challenge, in that all the statute says is you require your employees to attend a course. It doesn't say every 2 years. It doesn't say remain current. It doesn't say everybody has to be certified. It just says the employee in question had actually attended the course. The second element is the employer requires its employees to attend, which you could do by policy or procedure. Now, I get it.
I'm
if
watching it.
That's my requirement and then nobody does it. But I think all these extra add-ons and these creation of rebuttable presumptions are way beyond what the legislature intended. I mean, the legislature in passing the statute said, if you in good faith as an employer voluntarily make your people go to these classes and you're not wink, wink, nudge, nudging, right? The direct, indirect encouragement, the case law on that talks about, okay, everybody's certified. So, okay, kids, go ahead and have fun now and serve to whoever you want because I'm going to get the get out of jail free card. I mean, the commission under the Parker case has the burden of proof of showing that that's going on behind the scenes. And what I think this rule does in the old version and even more so in this new version is create a burden on employers that are out there trying to do the right thing to, quite frankly, make it virtually impossible for anybody to assert and behoove themselves of this statutory defense. I mean, you're really getting into the grains, fine, splitting hairs on if the person in question has a certificate at any time, that then every single person that's worked there for the past 2 years has to have a card. I mean, if you're a restaurant chain with 60 employees that's going through lots of challenges during COVID, and to go in and in practice say, here's every single employee going back for 2 years. Here's every single card for going back for 2 years. That's putting a burden on businesses that doesn't exist under the statute. And I think, somewhere down the road, somebody's going to challenge this as being an ultra vires rule.
Dewey, thanks for your comment. I don't think that the statute requires the employer to do anything. It's what Shana pointed out earlier. It's completely voluntary. You track taxes, you track their payroll, you track so many different things. You can simply go onto our website, type in the information that you already possess regarding your employees that do handle alcohol, sell it, serve it, and process it through the establishment, and simply see if their seller training is current. It's easy to do. It's on the website, easier than ever before. Everyone has our sympathies regarding COVID. It's been difficult on the entire industry. We definitely want to recognize that. But I think public safety was a concern before, during, and after now COVID. So I'm not exactly sure how COVID changes the public safety aspect of simply requiring employees to be trained. It's up to the employer regarding what they want to do. None of it is mandatory.
I understand that, but in order to behoove themselves of the defense, the rule goes far beyond what the statutory authority grants the commission. All the rule requires is for an employer to show that the employee in question that sold to the minor or the drunk in that incident had actually attended a TABC course, not within the last 2 years, not currently. It just says, the statute says the employee has actually attended the course. 2, that the employer requires its employees to attend the course, which could be by policy. And 3, then under Parker, if the permittee can show elements 1 and 2 under Parker, the commission then has the burden of proof of showing that there's some direct or indirect encouragement going on, not the permittee. The permittee does not have that burden under Parker.
I think to back it up, I think we disagree on exactly what the statute says. You're saying that the employee, it's right here. The employee that served the drink is required, but the statute's actually plural. In 106.14A1, it says the employer requires its employees to attend the commission-approved seller training program. It's not simply the employer or the employee that served the drink.
I was speaking to the first element.
Where it says the employee has actually attended.
Correct.
Right, but I don't think that negates the requirement of number one.
All right, I had them reversed in my head. One is required to attend. Two is the employee has actually attended. Again, why a employer has to go and show every single employee for 2 years when that's not a requirement under 2, right? You guys are imputing this 2-year have to go every 2 years when that's not in the statute. All the statute says is they attended a program.
I think SOA cases have already addressed this to say that, you know, requiring your employees to attend, it's not sufficient to, for example, if you hired an employee in 2010 and they took the course, that you never have to require it again. They just, that one little time they took it in 2010 is good. And here we are in 2021, they never re-upped, they never revisited the course. We don't think that that's the intent of the statute. We think the active verb requires its employees is continuing and ongoing. All of our permits expire eventually. And this, while this is not a permit or license, we both agree on that. It's just simply a certificate. But we think that once it expires, they need to take the course again. I think that might be something maybe for.
But that's not what the statute says. If that's what your legislature intended, then they would say that the course lasts only 2 years and that you have to be currently attended. That's not what the statute says. The statute merely says the employer requires its employees to attend and the employee in question has actually attended. So all these rules are way over the skis on that, in my opinion. And this current version, I think, goes even more so than the current practice. I'll leave it at that. Thank you.
Thanks, Jay.
This is Amy Harrison. At the introduction of this rule, what I understood to be said was that this rule's needed in order for the commission to do its job. We've been under the old rule for quite some time, and I guess my question is the old rule not allowing you to do your job? Are you losing cases? Are there things going on that the rest of us don't know about that's brought this about? Particularly when you say you need this rule to do your job, what's been going on in the past? And can you be specific about lost cases or things that are occurring with public safety that are serious enough to bring about all these further restrictions on retailers, particularly at a time when we're all pretty well struggling? So I just appreciate some background and some clarity as to why, to do your job, this is necessary.
That's for you.
Yeah. I don't think that anyone has said any of those elements. Lost cases, I don't have a list for you today, or any other types of issues other than we simply think that this rule tracks with the statute better than the prior rule, because there's no burden on the permittee to basically there's no requirement for the permittee to require its employees to be trained. It's completely their self-election to do so if they want to avail themselves of this affirmative defense. They're the ones that are in the best position. They control those records. They have all the records of who they hire and for what jobs. If anything, I think the definitions for employer and employee are helpful to the employer, because it clearly carves out an exception for those people that work for the retail place that are maybe, let's say, marketers or social media influencers, that then wouldn't be required to be trained. I think it kind of makes that clear in the definition section, because they don't handle any phase of the alcohol service or selling, serving the alcohol. So I don't have any specific examples, but it is the permittee's affirmative defense, because it says, any actions of the employee will not be, I can read it, shall not be attributable to the employer. The employer is the one that is in the best position, controls all of those records. So we simply think that they should be the ones to produce them. instead of TABC scrambling to spend time investigating to try to prove the negative.
Yeah, and I mean, just to expand on that, I have definitely heard from our folks trying to prosecute these cases that there's a lot of time spent trying, like pulling teeth to get these records from the permittees when, you know, these records should be pretty readily available, but they'll do just about anything to prevent the agency from getting them. So, you know, it's a problem. It is a problem because we're spending a lot of time and energy and effort just trying to compel production of records that should be very easy to access and given freely.
Especially if, go ahead.
I'm sorry, I didn't mean to cut you off. Go ahead.
Okay, I was done.
This is Edgar again. I'm struggling to understand this difficulty getting these documents. I mean, you have a subpoena power under 5.44 of the code. You also have requirements, to comply with that. You can enforce that through district court. And then also, if it's disputed, you ask for a hearing, and then you have a judge that can order people to produce those documents. They don't. I mean, you lose the hearing, so it just seems a little hollow. And the other that I'm really concerned about is also watering down what kind of disqualifications there are for purposes of similar incidences or whatnot. Under the current rule, the way that it's written is you have to have 2 prior similar incidences, and those have to be adjudicated. Whereas here, as written, you take out the word proof, so that means purely on an allegation of TABC, and also you take out the word similar incidents. So let's say we have a situation where, I have a client that's charged with sale to intoxicated person, and within the last 12 months, they have a unresolved cash law violation and maybe a warning for open saloon. Under the way that things are written right now, TABC could arbitrarily just disqualify somebody from safe harbor. And I just want people to be aware this is not good for the industry.
Well, this is this is the very first step of the process. So, and I don't think that was our intent. And I think that's a good comment, Edgar. And we appreciate you pointing that out because we might need to tighten up that language a little bit. And we didn't intend to make it
Definitely not
quite that broad. We're not, that's not something that we're wanting to do, to disqualify you for a cash credit violation, obviously. So that's a good comment, and we will tighten up that language accordingly.
And Edgar, if you have suggestions on how to remove the effect that you're alleging that a cash credit law would somehow count against them on a future public safety violation, let's specifically address that. And those types of violations that I would agree with you, absolutely shouldn't be considered in something like this.
Yeah, thank you for that.
This is Bill DeFore. I echo Dewey and Edgar's comments because I've always felt like that the initial rule that was drafted a long time ago went beyond the statute. I'll leave it at that. I do want to point out in section, I guess it's D, the last sentence where it says employees must be certified prior to selling or serving alcoholic beverages while they're the only employee on the premises. Why is that sentence there? And help me with that one. I mean, it also almost implies you can't have anybody serve unless they're certified. Now, I would think maybe what you're trying to do is say that if there is a violation and that's the person that did it, too bad. I don't know. Tell me where you're going with that.
Bill, that's a good observation. You're under sub D, correct?
Yes.
Okay.
Yeah, sub D, I'm sorry.
Oh, no problem. I'm just for everybody. Employees must be certified prior to selling or serving alcohol while they are the only employee on the premises. Well, I'm sure you have clients.
In order to take advantage of the safe harbor.
Absolutely.
This is just in the context of safe harbor. So if you're the only person there, there's nobody else on the premises, it's an employee, then that person needs to have be certified in order to claim the safe harbor. They can't be.
And I understand that. I just think It's just kind of sitting out there by itself. I don't know, maybe that's just me, but I think you could tighten that up to say, and I understand if it's the only employee and he's not certified, he gets popped, that's too bad, he's done. But just to sit out there by itself, and that's all I'm saying. I also have an issue with this 5 days. Why did you go from 30 to 5? 30 was the previous rule, I believe.
I don't think at that time during that rule when it was passed that it was so easy and it was so inexpensive to simply go online and take safe harbor. You know, now through COVID, it's even easier to simply, I didn't mean to say take safe harbor, sorry, to take a seller server approved training course. It's easier today more than ever before to simply jump online and take that course at very affordable rates. So there would be no reason to drag it out for 30 days when one of your employees needed to go attend a class in a classroom somewhere. They could simply even take it on their phone.
Well,
So we thought,
yeah, I mean, 5 is pretty quick. I understand the 30, but 5 is just awful quick, especially given the fact that retailers can't find anybody to work anymore. And so they're strapped. Anyway, it's just an observation. So thank you.
Hey, this is Dewey. Let me echo on subsection D. Just again, I'm not for clarity. That first sentence, providing proof, including the applicable TABC form. I don't know what that is, where that's referenced anywhere else. If we can have more clarity on what the applicable TABC form is and where it's supposed to be filed and provided. I don't know if that's the seller training certificate that the schools issue. I just don't know what that is.
I think in reference to that, compliance at TABC would come up with a form to make it easy for everybody to be on the same page on providing the information regarding your qualifications that you met, the safe harbor defense. So it would just be a form that you could fill out. Here are employees, maybe these are their jobs, this is their personal information, or here are their certificates are attached. Something to help people know what to file instead of just stuffing copies of seller training certificates in an envelope and handing them to an agent. It'd be something to help you memorialize the proactive steps you took before the incident and that show why your retailer qualifies for the defense. I think that's meant to be helpful, just to get everybody on the same page, because otherwise your retailers would ask, not everybody hires a lawyer like yourself. So they would ask, well, what is it that we're supposed to provide you? What do you want? How do you want it? Where do we send it? Something that would help to that effect.
I think that sounds like a good idea, but if you're going to do that, that should be part of this rule so everybody can review it and know going in and have it be referenced in the rules so people don't have to guess where it is and figure it out on their own.
We'll consider that. Thank you, Dewey.
If I could just echo the form situation, and maybe it's because we're all coming off of this AIMS implementation and the forms and the fact that they change and we have no instructions and they don't make sense. But for sure, if we can have better communication when it comes to just forms in general, that would be very much appreciated. So if a form's going to be created out of this, if we could all have at least instructions, if not input, that would be awesome.
Hi, yes, my name is Catherine Chambly. I work for Bracken Schwartz as well. And I just want to clarify, so is this form instead of your current 10-day affidavit language? Because I don't see that referenced anywhere, where you had to previously provide an affidavit within 10 days of a violation, which I will say was difficult to pro se people, I'm sure, never did it, because they just had no idea. And we could do it, but it depended on what violation, was it the ticket? Was it when legal sends you a notice of the violation? And I noticed that language is no longer in this rule. So is this form that is going to be created in lieu of the prior language regarding an affidavit?
It's not the affidavit. I know exactly what you're referencing, Catherine. It would be outside that, and it would be a form just to help, like you said, those pro se permittees know what to submit to the agency in an easy manner, in a way that we can accept it, would also hopefully resolve a lot of issues on the local district level, right? Because not every case goes straight to legal. Sale to minors, those could be settled at the local office, as you know. So if they could walk in with that form and show that they've complied, it would be something that the local district office, the sergeant, lieutenant, or major, whoever's going to settle that case, it would be something that they could more readily accept, and it would help move the process along. I think it's actually going to be hopefully helpful to the retailer, both sides actually. But it's not the affidavit that you're referencing.
So is it instead of though the affidavit, like from our standpoint, like I feel like, the lawyers, we're held to a little higher standard than pro se as far as knowing that an affidavit has to be filed and it has to be done within 10 days. So I just want to make sure there is no longer an affidavit requirement. So instead of that, we would be submitting this form with the attached documentation. And then second, is there a time frame for that or no?
This is in lieu of the affidavit. It's not an effort to try to address that affidavit, but no, the affidavit would no longer be required. Now, this might require notarization, so it's a sworn document, because it will have extraordinary ripple effects, because as you know, a lot of these cases that we handle, there's also a tandem district court case brought via dram shop action, Chapter 2 of the Beverage Code. So whatever's submitted to us could have effects in that district court case. So we might require it to be notarized.
And of course, everything you submit to the agency, you're submitting that it's true and correct to the best of your knowledge. So, and there's a penalty for submitting something that is not true. So.
Oh, no, I didn't have an issue with whether it was notarized or actually, legal document, more so the 10-day part of it. And does it have to be in the form of an affidavit, or, I guess it was this in lieu of instead of me, as soon as I see my client gets ticketed for sale to minor, let's make sure everyone's certified, draft the affidavit, get it to the permittee, all within the 10-day calendar, 10 calendar days. Instead, I'm going to be pulling up this form and I'm going to be filling out this form, but I have time to do it. It's not like in 10 calendar days, I am in violation of this rule, essentially.
Well, this is also, the third word here is permissive. It says an employer may demonstrate compliance by providing proof, including the applicable affidavit, not affidavit, but TABC form that all of its employees, except for the incidentals, so it's permissive. You don't have to do it. It's just a vehicle that would hopefully help people, like you referenced earlier, that might be pro se, try to help them show that they've complied. It's their defense.
I guess what I found before is that sometimes that affidavit ended up being excluding people, as in so much as, like, if we filed it, this actually occurred sometime in the last couple of years, or, the comment was, well, actually, this was filed 14 days after you got your initial citation. So now you're in violation of the rule, and maybe that safe harbor defense doesn't apply anymore, And so I guess I just want to make sure that.
Hey, I got a quick question for you. Darren Cisneros.
Okay, just
Okay, it looks like somebody turned off their mic by accident. Catherine, I think you're getting into the province of the decider of fact there. That would be up to the ALJ to decide if going 4 days over the current rule somehow disqualifies them, but I think they would have to weigh whether or not you complied with the statute.
But the 10 days is no longer in this rule.
1, 3, 2, 4, 5, 9, 8, 7, 3.
That's not me. Yes.
Everybody mute.
That was Catherine Chambly for the
No,
record.
sorry. Oh, don't blame me. No, but yeah. So I guess my question in the end was: is the 10 days no longer in there anymore? Like this rule doesn't seem to have the 10-day aspect anymore.
It's not there, so that wouldn't be a violation anymore. We are 8 minutes over, and we still need to talk about e-commerce. And I know we knew this was going to be a hot button, and there would be a lot to talk about, which is why we have a second stakeholder meeting coming up in December. on chapter 49. So you've got time, and I would appreciate it if y'all would communicate with me between now and that December second stakeholder meeting so that we can make some revisions that would address the issues that you brought up today. And also, if you have additional issues that we weren't able to get to today, you can bring them up then, or you can certainly always give me a call or shoot me an email in the interim. But we've still got plenty of time on this one. This was draft number 1. We will work on draft number 2 with your help, and we will come back again for another meeting in December. We need to, unfortunately at this, Your Honor, I'm not a cat. We need to move on to the e-commerce advisory right now because there's a lot to talk about with that too. So I do apologize for cutting it off, but as you know, we're never cutting it off. You are always welcome to communicate directly with me, and then we will have a second stakeholder meeting on this. So it's not going to move all that quickly. It's going to be plenty of time to discuss and work on it. I am going to cede my seat now to Matthew Cherry so that they can talk about the e-commerce advisory.
All right, now on to the very, very, very most exciting portion of today's event, e-commerce. By the way, like Shana said, I'm Matthew Cherry, attorney for the commission, and with me I also have Thomas Graham. Before we kind of go through the advisory, I just want to have some kind of starting points to let everyone know about. First, that this is the agency's very first attempt and to try to put out an advisory on this topic. This is nothing final by any means. We really intend this to kind of be a kickoff for a longer ongoing discussion with industry so we can get to a really good final product. In saying that, we also plan on having this stakeholder meeting, getting a bunch of feedback from industry, kind of going back internally, looking at the advisory, looking at all the comments that we receive and all the information, and then kind of putting something together as a second draft, and then also having a second stakeholder meeting based on that. So that's kind of our intended timeline. And the general direction we were trying to take with the advisory was kind of take some of the general concepts within the code that we feel would be applicable to all the online platforms. We did attempt to kind of put some of the platforms into different broad categories, but I also recognize that there may be some overlap between these. But overall, our main goal is we do want to support innovation within the industry while also ensuring that it aligns with the 3-tier system. Okay, so now I'll kind of go into a bit about the advisory, but I'm going to kind of rush through this because I want to make sure that there's ample time to go through a lot of questions and everything. Okay, so at the first page, it really just kind of goes through some background, talks about the Wayfair case, and then we have some references to the marketplace provider provisions that are in the tax code. And the purpose of that being in here is just to kind of make everyone aware that it's something that the agency is looking at, not that the agency has any kind of intended actions in the future with it. It's just something that kind of does apply to this category of topics. Next, we kind of go down to page 2, and this is where we start to get into the way that we've kind of tried to separate some of these platforms into categories. So the first one really is what we're kind of calling a sales-only platform. This is something that we see as more solely technology-based, and it's really just connecting an individual consumer with the partnering retailer's inventory to facilitate the sale of alcohol, but everything within the platform, or at least that is specific to that retailer, especially in regards to accepting orders, is fully controlled by that retailer. And then we go into what we're kind of looking at as dual platforms. So this is something that is similar to the sales only ones, except that we've seen a few of these platforms that have kind of been brought to the agency's attention, that they end up having a more of an increased involvement, especially with like the control aspect over the advertising on a platform that's going to sell alcohol. And especially one of the concerns that we have are funds coming from a supplier that are going to be then used to have any sort of specific product placement. And that's one of the big issues that we try to look at. And then after that, it really just goes into kind of looking at some concepts within the code that already exist for brick and mortar stores. And we did think that one of the best ways that we could kind of make an analogy to these online platforms was to kind of put it in the context of the same way that we enforce regulations within the, the physical stores. I think we all know that most of these statutes are written before the internet even existed. And so this is just a concept that we're trying to, fit within what's the current language within the code. I think I'm gonna move down. Well. All right, I'm just gonna talk because the mouse is having a lot of issues. Okay, so next, what kind of bleeds into that is we try to kind of take the concept of digital advertisements and we put that more into exactly how we regulate signage in stores. And then lastly, one of the other main things is the section that talks about e-commerce interaction between upper and lower tier businesses. I do want to kind of point out with this one that we already plan on going back and revising a lot of it. And we recognize that, I think there's some stuff in here that talks about specifically not allowing upper tier members, and I would say kind of in the manufacturing tier, from engaging at all with retailers. And I also want to point out that we do recognize that there are some types of manufacturers that obviously get to make direct sales to retailers. And that kind of covers everything. Obviously I would love to talk more because I could talk all day, but we only have about 15 minutes left. So I kind of want to open the floor to have a couple questions and to receive feedback. Okay, looks like we have some hands raised. First, I think it's Bob Budoff. Bob, if you're speaking, you're still muted.
Or not? Okay. Okay. I'm with the Distilled Spirits Council, Bob Budoff. Sorry about that. And on behalf of our members, I have several questions that I wanted to ask. To start with, you referred to the initial section where you talked about some of the background. That's very general. And we wanted to know if you could provide us with any more specific information regarding any internet or marketplace activity or any other factors that underlie your decision to issue this draft.
I believe the main factor would be it's probably about maybe a year ago, and then kind of continuing on after that, we've had a couple entities approach the agency with kind of mock-ups of their platform and specifically trying to ask, which sections or which portions of our platform comply with the code, does the thing comply, as a whole, and they really wanted to get TABC kind of specific approval. And so we thought that based off of that, the best approach would be to try to put out some draft guidance that will kind of go to the industry as a whole, and then that would help kind of spawn a larger discussion to really kind of dive down and more into the weeds of some of this and create a new draft that'll, really give a lot of guidance to industry members and people that are trying to put new platforms together. And I also think one of the other big factors, partially is COVID, and right now internet sales of alcohol are really expanding, and we don't think that is going to decrease. It's most likely going to increase in the future.
Let me ask you, following up on what you just talked about, third parties coming to you with their internet platforms, can you give us any examples of internet platforms that you have either formally approved or indicated would probably be okay? And conversely, are there any that you have given a negative nod to? So we have a better idea of how this could apply, even though I know this is preliminary.
At the moment, we kind of have stayed away from doing any sort of official approvals with anyone that's brought us their platform. We thought really that we needed to have this larger discussion and start engaging a lot more with industry before we could make that decision. Obviously, we're the regulators here. We're not the ones that are actually, running a business day to day and kind of really interfacing with these platforms. So I do think that there's a lot of things that maybe the agency doesn't fully understand yet. And we need to kind of have more discussions with industry so we can get a better understanding and then kind of go back and see how everything fits within the code.
Let me ask you about some of the terms that you have in the advisory, which weren't defined. Retailer's website, I think, is pretty obvious, but you also use this term retailer branded website. And What did you mean by that in contrast to just the retailer's website?
Okay, that's something that I guess a specific definition we're still kind of working out, but I can tell you kind of the direction and the thought process behind using that type of language. Obviously, on one hand of it, it's going to be something that I think you're kind of touching on. If I had Matt's Liquor Store and I went out and asked a developer to create a website for me, that people go to maxliquor.com, and that'll help kind of facilitate orders and show my inventory. And so that's kind of one side of it. And then I would say on the other side of it, what we're also looking at and consider that to be is maybe a kind of like a multi-retailer platform that has, within it specific pages that are going to display or link a consumer to a particular retailer.
I see. So that is really like an unlicensed third-party platform when you talk about retailer branded websites.
Yes, it includes that. It does include that as well. Yes.
Right. You talked about the fact that this is only the beginning of the process, and that was an area of interest to us because we just got this a couple of weeks ago, and we're just really mulling it over. Can you give us any timeline or when we can submit comments until, and when we can expect to hear from you about what the next steps are going to be in this process?
About a month, that's fine. Yeah.
Okay. Yes. So, we will start taking comments and, set up any phone calls that people want to have, starting as early as Monday. And I will say, like right now, we don't have necessarily a specific timeline, but I'd like to say, let's give everyone at least a month to kind of review stuff, have discussions within their businesses, and then give feedback to the agency. That's not a hard timeline. If something happens and we just get a flood of information, it may take a little bit longer for us to put out a second draft. But this is not something that we're going to make a very quick decision on. We really want to engage with industry a lot, have a large discussion about this, and get a really good final work product.
Thank you. I think that's about what I have for now. Thanks.
You.
Thanks, Bob.
All right, Marcus, you're up.
Thank you, Matthew. Marcus Schwartz, Bracken Schwartz PLC. I think you've probably rightly used platform as kind of a nebulous thing because you aren't sure exactly what a platform is going to be or could be in the future. But that obviously it's hard to know though at the same time what would be cool and what not. For instance, is a POS a platform? Is the screens next to a gas station, the pumps, is that a platform? Then do retailers run into problems when is that rendering a display service for a retailer? I don't know the answers to these, but things to think about. Say it's a third party service, how much input can a retailer have on a third party's platform before it becomes a retailer platform, right? Say, oh, I want you to use my logo and I want you to list drink prices first and food second. Like, is there a line to cross where all of a sudden it becomes a retailer platform as opposed to a third party platform? And then the implications with, potentially upper tier advertisements there. That's another sticky wicket for you guys. And I don't know if this is something that you guys want to go down the road of, but Thomas, you laid this out with kind of the billboard thing, right? With billboards on retailers' permits, right? As long as enough money is coming in from non-alcohol sources, then you can have alcohol sources. Maybe that's something to think about with these platforms, is that as long as, say somebody's paying the retailer or some third party's paying the retailer, right? And they're also getting upper tier funds. Maybe as long as they get enough money from non-alcohol sources to cover that payment, then they could do alcohol sources. I think that's a nice commonality that would make sense from the agency perspective. Just running through my notes here.
And that's one of the ones we're debating too, Marcus.
So the e-commerce, I guess, distributor platform, you've kind of laid out that's really. Suppliers aren't supposed to have that direct to consumer. Can a supplier be involved in a retail and in a distributor platform? Can they do one together?
I think that's a good question. I mean, my kind of first inclination is going to be, no, I do not think so, not necessarily. I mean, our idea with this was not really to allow, or I don't think the code does allow a lot for supplier involvement in maybe what we're thinking that type of platform looks like. I will say, when we were kind of looking at some of the language for that last portion, we weren't necessarily envisioning that it was the same as a lot of these consumer facing platforms that have a bunch of advertisements all over them. We were maybe thinking of something that's a little bit more basic that really just kind of digitizes the submission of orders. So I think what some of the stuff that's out there right now is just a lot more complex than what we were trying to maybe talk about in this section of it, which is also why I think it's going to need to kind of go back and have some redrafting to it.
I get that. And I'll just put this out there, think of the old school way. Like, suppliers used to go along with distributors on sales calls, right? They just couldn't make the sale, right? But they could fully participate and do all that stuff. And so, to me, this e-commerce is a divergence from that, right? If the supplier cannot be involved in any way.
Okay, I mean, I fully hear you on that. I think that these are a lot of good suggestions, and this is the exact type of feedback that we would really like to get from a lot of industry members, especially maybe just submitted, either via email to Thomas or I, or it can be a formal letter to the agency. But the more of that type of stuff that we receive, it allows us to kind of incorporate and think about those concepts for the advisory.
That's it for now. Thank you.
Thank you.
Okay, the next person that has their hand raised is Dr. Prashant Desai.
Yeah, hi.
One's names.
Hi, it's Dr. Desai. Can you hear me?
Yes.
Yeah, so I am the executive chairman CEO of Bottle Caps. Bottle Caps is a Texas-owned and operated provider of software-based marketing solutions, primarily for the retailers operating here in Texas and throughout the US and Canada. As a company that was founded in and still calls Texas home, we work with retailers of all sizes throughout Texas and built our business model in order to be compliant with both the TABC code and the administrative rules. As such, we specifically designed our services to comply with the Texas three-tier system, which federal law has held unquestionably legitimate since the 21st Amendment. So in terms of, we want to thank you for trying to put this together. Again, we think there needs to be some guidance, but we also had some concerns around the direct sales platforms in terms of comparisons with retailer branded platforms, particularly in its effect with regards to local retailers. But we look forward to working with you and in clarifying this.
Okay, great. Thank you. All right, next up, I don't see any more hands raised, but we still have a couple more minutes left if anyone has any more comments or thoughts.
Amy, I just want to say that I can't imagine the work that's gone into this, and I'm appreciative of that because it looks confusing and complicated, as I think it probably is. And has any other state attempted to put their arms around the e-commerce like Texas is at this moment? And if they have, what are their enforcement efforts? Because I read this and I'm thinking, holy cow, how is this going to be enforceable? And what's that going to take? And I'm just curious about, this is an incredible amount of work. What were your resources? And, have you seen other things that have been successful? And what do those enforcement efforts look like where these things are occurring?
Some of that is stuff that we are still kind of looking into. I'm not aware of another specific state off the top of my head at this moment that, kind of has tried to take this approach into kind of as much depth. When we were initially putting some of this together, I was trying to do some of that research. And then at some point we decided, okay, even though a lot of other states have very similar concepts, Texas, the language is not exactly always the same. And so we thought for kind of the first draft, we're going to focus on, the language in the alcoholic beverage code for Texas and kind of put something out there. And then hopefully that'll spawn maybe a larger discussion. And we're going to continue to look at and see what other states are doing. Now, when it comes to enforcement, I can't tell you exactly how that would work out yet. I think we're going to have to get to a final draft, and then maybe we can have a larger discussion about that at that point in time.
Amy, I will say though, we are looking at what other states are doing, and that is part of what we're doing before our second draft, like Matthew said. So we've actually had some other stakeholders come forward and offer to bring us some information on that and what other states are doing. So we're kind of waiting on that. And we're doing some research of our own. So please, anybody that has any input, bring it to us in writing would be great. Gives us the time to go through it and really talk about it. And then, of course, we're open to any meetings or phone calls as well.
Yep.
At time, so.
Okay.
I was just going to ask real quick on your December stakeholder on the safe harbor. Is that going to be prior to issuing or putting the rules in the register?
Yes, it will.
Okay, that's all. Thank you, guys. Appreciate your help.
Well,
All right,
thank you all.
All right, we are out of time. This is a great discussion. Thank you all so much for being here today. And as always, the lines of communication with us are open at all times by email and phone. And we'll be back to see y'all again on a couple of these topics in December. So thank you very much. Have a good Friday.
Thank you.
Thank you all.